Spiegel. Mr. Sander, you're going to begin. You'll be first.
My name is Bruce Sander. I represent the Stony Brook concerned homeowners. I've been here before. Good evening. I just want to thank the board for their continued support in helping us, sometimes in creative ways, to combat illegal housing in the town of Brookhaven. Our community action group has already in existence almost 2.5 years, and we have developed a very good working relationship with this town. We have witnessed some positive changes in our community, with some of the former college boarding houses being sold to families. Some that are for sale are so beat up that think about buying one would have to invest hundreds of thousands of dollars to make them livable. But I guess these landlords believe students do not need homes that are clean and safe environments to live in. Our single-family homes are stick-built construction, not designed to house numerous students. With Supervisor Romaine's help, the town has a day in a local court. This is set aside just for hearing housing cases. This new judge on the bench, which itself is a positive. Moving forward, the community now needs to see the use of search warrants, where an egregious landlord is blatantly violating the laws by jamming too many students into a single residence. We have a number of these identified blatantly skirting the town every day in existence. To use warrant effectively, the town must approve 24-hour surveillance of this house in question for the period of time that the warrant is issued and the time of the actual inspection. This is the only way to watch these landlords move their students and their mattresses out before the warrant is enforced. These are very crafty landlords who will do whatever it takes to line their pockets at the expense of the community. In order for any code enforcement to work, the town investigators cannot be restricted to a normal workday. They must be able to do surveillance in the early morning hours from 6 a.m. and later in the evening, 10 p.m. on. Without this ability, the town investigators will be spinning their wheels because there is no one home between 9 and 5. Violations will not be visible. I understand there was an additional investigator added, but this one person, if they can only work 9 to 5, will be of little or no consequence. Overtime is expensive, but so is the damage being done to our single-family neighborhoods. The law department has probably added more revenue to the bottom line than it would cost the town. I understand ISOP has added many investigators to their staff, and it is said that they are more than compensate the cost of these investigators through increased volume of fines assessed. Please redirect funds as needed to accomplish this, because without it, we're wasting our time here. I, for one, have been fighting too darn hard and too long to allow this to happen. We need the law department to seek warrants to inspect these illegal properties. We need surveillance to win them. I want to thank Supervisor Romaine and Councilwoman Cartwright and the town board for all your continued support. And I will be speaking in support of the amendment before you for the parking in the next session. Thank you.
Thank you.
Introductory. Public hearing number 2 is introductory local law number 23 of 2015, amending Chapter 82 of the Code, the Town of Brookhaven entitled Neighborhood Preservation by adding Section 82-10G, Registered Motor Vehicle Restrictions. Legal notices of public hearings are published no less than 10 days, no more than 20 days prior to a public hearing in one of the legal town newspapers. Our office has received the signed affidavit of publication from the newspaper. Should the board render a decision tonight, this has been deemed a secret type 2 action, and we have received one opposition letter from the Coalition of Landlords and Tenants of Stony Brook.
Sure. Okay, and we have Dave Moran from our law department to explain this proposed local law.
Good evening, Supervisor Romaine and honorable members of the board. The proposal tonight is to seek to limit the number of registered motor vehicles that can be present upon property at a rental dwelling to one registered motor vehicle for each legally designated bedroom as determined by the chief building inspector, as well as one additional motor vehicle. So, for instance, on a rental application or rental permit that is approved for 4 bedrooms, they would allow to have 5 vehicles. Also in this legislation, as it is a zoning ordinance attempt to regulate the use of property, we've built in an appeal process to the Zoning Board of Appeals, wherein someone who's renting a home as a traditional family under the code legally has the opportunity and afforded the same rights as anyone else in the community, in that if they need additional vehicles, there's certainly a mechanism for which they can come in and comply. Such legislation is designed through zoning regulation to regulate uses on property, not users on property. which is a permitted purpose. Portions of the town of Brookhaven exist in such a way that there's very narrow streets, limiting traffic flow, creating public safety concerns, causing emergency vehicles not to be able to pass, first responders to seek alternative routes. In an attempt to protect the health and safety, a resolution like this is necessary to try and get some of the street traffic off the street and try and maintain the vehicles within the confines of residential dwellings. Additionally, during times of emergency such as snow emergencies, plows need to get through, and the proliferation of vehicles upon our streets is something that is paramount during those times for public safety concern. Street sweeping occurring in the springtime and other times to make sure that the roads are not slippery and that the sand and salt are properly cleaned up also creates a significant public safety hazard. Zoning regulation is also available to protect and maintain the residential character of our streetscapes, and we do this through this type of zoning regulations. However, sometimes when attempting to regulate uses on property, there exists a collateral effect on users of property. There's a seminal case in this area. It is Casper actually versus the town of Brookhaven. And the holding in that says that this distinction between homeowners who occupy their homes and those who do not was deemed rationally related to a legitimate goal of zoning. While zoning has its purpose to the regulation of land and not landowners, as a practical matter, many zoning laws extend beyond mere regulation of property to affect the homeowners and users thereof. The Casper Court found that owner-occupants may be treated differently than absentee owners as it relates to the obtaining of accessory apartment permits. Here, in an effort to regulate through the town's zoning power the use of property to protect health and safety and welfare of the good citizens of this township, by limiting the number of vehicles which may be present upon a property which is non-owner occupied, may very well have a collateral effect on some users of property. However, nonetheless, shall be held constitutional under the holding in Casper. Further, this legislation falls in line with other East End towns who have similar legislation which has yet to be challenged. I'm available for questions from the board.
Thank you. Questions from the board?
I have a question. And when you say, just for the audience and people watching, on the property, has to be on the driveway, not on the front lawn or elsewhere on the property, on the demarked driveway, correct?
This legislation doesn't necessarily specify where the vehicle needs to be.
But other sections of the code?
It does, but it just limits the number thereof.
Okay.
But other sections of the code address proper parking in the driveway or loading area, as our code calls it. This section of the code, however, just limits the number.
Okay. And you believe what we are doing here tonight is in our zoning power, in the fact that it has, beside the fact that it hasn't been challenged on the East End towns, it would survive a challenge under the, say, 14th Amendment equal protection, because some people may say, and may argue here tonight, that we're treating homeowners and renters differently. And can you just repeat that section so that way
Sure.
there's an understanding that you're giving us under the law?
Sure. Just in following line with your thought, as the Casper Court found, when you regulate zoning, although the principal purpose is to regulate the use of property, there sometimes is a collateral effect on users thereof. That court found it certainly permissible to treat different classes of ownership differently, i.e., owner-occupied versus non-owner-occupied dwellings. Obviously, when you bring about comprehensive legislation to bring about and protect the health and safety of the residents, sometimes you need to push the legislation into areas where it may not have gone before. And that's why if you look at the evolution of any one of our codes and where it started and where it ended and the challenges along the way, I can't sit here with 100% certainty and say some court somewhere may or may not overturn this, but I think we have a good statute. I think it does push the bounds a little bit, but sometimes we need to do that. We need to put as many tools in our shed to combat a number of problems. This has an effect on public safety and streets and our ability to traverse our roadways safely, as well as, I can assume, effective legislation and enforcement of our housing code.
And would you say this is in the same vein that we treat those that rent a whole home are not eligible for an accessory apartment? However, those that own a home, owner-occupied, are eligible for an accessory apartment. Would you say it's in the same vein of thinking?
Yes.
Thank you.
Okay, other questions?
I have a number of questions, and then I'll reserve some until after the community speaks, because I believe there are a number of cards. As it relates to the parking itself, you've indicated that the statute doesn't say if the parking is on the driveway or off-street parking, correct?
Correct.
So when you're looking to write a ticket, are you looking, and a complaint is made that there are a lot of vehicles parked in front of the house as well as in the driveway, what is the assessment that's done if the statute doesn't specify where the parking should be?
Other statutes do.
We have a staff of law department investigators whose job it is to investigate. Like any one of our statutes, we can get a complaint that there's 25 people living in a house. We don't just get to drive by, snap a photo, and say, okay, here's your ticket. We have at our fingertips DMV records and searches, and we certainly have the ability to do surveillance and monitor the comings and goings. We have the ability to interview. So it would need to be enforced like any one of our codes that need investigation. This is not you're parked in a handicapped spot without a placard, here's your ticket. This is the purpose of statutes like this, is why we have investigators as opposed to inspectors, as opposed to code officers. This type of legislation would need to be investigated by investigators to be enforced.
Okay, and for it to be investigated, is it safe to assume that many times the investigators would have to see if the cars are parked there overnight to see if in fact they belong to that home? I'm trying to understand the procedure here. I think it's a bit difficult, in my opinion, to enforce it, but I'm asking the law department to explain to me and walk me through how it would work, because I believe that once the actual proposal went out, in the news media, stating that we were looking to change our code to include this, some of the students and people who were parking many cars in one driveway started parking around the block in front of other people's homes, and I'm trying to see if, in fact, it would affect other people, innocent people, who had students' cars parked in front of their home.
I can't even imagine to render an answer to that question. Are there people out there who, when we implement code to bring about and protect the health and safety, do everything they can to circumvent that code, to line their pocket or to do, ulterior motives? The intent of this code, as it was drafted and as it was proposed during my presentation, spoke of public safety and trying to limit the proliferation of vehicles on the street. If the ancillary effect is somehow affecting housing, so be it. And it just becomes another tool in the shed to enforce our Chapter 82 in reference to housing throughout the township. To say there's not unscrupulous people out there or scrupulous people out there who find a way to circumvent the code, of course there is.
Okay. And the code specifically indicates that it applies to rental dwellings. And then I looked up the definition of rental dwelling, and it says condominiums, cooperatives, two-family home, three-family homes. Is it going to apply to that as well?
And where did you look up that definition?
It's just the only definition of rental dwelling that I saw in the entire code.
No.
Okay. So what is it applying to specifically?
Single-family homes. One or two-family homes in residential communities. I believe condominiums and others are zoned differently. It could be zoned
So
differently.
that would be in furtherance of our A zoning category.
Correct. Or B zoning category or other zoning category. Residential zoning classification.
Multifamily, that
Correct.
would be a PRC, PDD, multifamily MF, correct?
Correct, Counsel.
Okay. And you asked me where I found it. I'm reading 82-2, which says a dwelling unit established, occupied, used, or maintained for rental occupancy as a 1, 2, or 3-family dwelling, or multiple apartment units, or condominiums, or cooperatives. That's the definition of rental dwelling.
In which section is that?
It was 82-2. Okay, so I just wanted to be clear, but with this particular statute, we're only dealing with the 1- and 2-family homes.
Correct.
Okay. When someone is issued a ticket, who's going to be issued the ticket, the renter or the owner?
Owner.
Owner of the property. Okay. And I have, and it's not going to apply to accessory apartments, correct? Only
Correct.
rental permits, which clearly cannot have a rental permit as well as an accessory apartment.
Correct.
Okay. I have some questions more so about the constitutionality of it, but I'm going to wait until I hear everyone speak because I'm sure I'll have additional questions as well, and I don't want to keep everyone here all night.
David, I have a quick question.
Sure.
What provisions have been made for people with large families and grown children moving back home because of loss of job, divorce?
The statute as presented, Councilwoman, it has two sections. One is the law itself, and one is the ability to vary from the law. And under those circumstances, if you have for instance, and for example, a 4-bedroom home, and you're allowed 5 vehicles, and you have an influx of family members into that home for whatever reason, it's certainly within your right to come and apply to vary from the code via our zoning board for relief.
Okay.
Do you have to pay for that?
I would assume so.
Okay. So owners of homes don't have to do that, but renters of homes would have to do that.
The permit is issued to the owner, and thereby the variance would also issue to the owner.
But if the owner is not renting, does this code apply to them?
How do you mean, Councilwoman?
If the owner of the house is not renting it,
There's a presumption in our code that if it's occupied by anyone other than the immediate family of the owner, there's a presumption that it is being rented for a fee. And it would be an affirmative defense to that for that individual to come to court, if prosecuted, to rebut that presumption. For instance, in your home, if you moved and you decided to just throw the keys to Marie Michelle and she moved in, there's a presumption in our code that that is for a fee. And it would be up to you to rebut that presumption. So ergo, this section would apply.
okay.
So the owners actually get the ticket, but the renters are the ones that would have to come to the zoning board of appeals and get because who?
No, the owner.
The owner, in the same vein in that the owner has to apply for a rental permit.
So as a renter, I'm living here at a home. I've been living there for 10 or 15 years. I realize I have an emergency in my home. I need 2 or 3 of my family members to come live with me. Do I have to now contact my owner, the person I'm paying rent to let them know that they need to now go to the town to apply for a special circumstance permit? I'm trying to understand the process.
Because you are adding people to the lease.
Is that the process?
I guess that could be one example of the process.
Okay. Well, since we're talking about this, my concern is that when it first came up in work session, there was this discussion amongst all of my colleagues. And the question was whether it applies to all homes in the town of Brookhaven or just to renters. When the question came up as to whether it should apply to all homeowners, there were a few people that said I would be in violation if it was me because, I have family members in the house, I have a certain number of kids, and those things were brought up. Then we said that we would reconsider it, take it back to the law department for review. It came back now that it was going to be only applied to rental properties, which seems to be a bit unfair and, in my opinion as an attorney, in violation or unconstitutional. Now, we spoke about this previously, and I asked you about some of the cases that came out in New York, some cases that came out in California, other cases that came out that specifically indicate that codes of this nature that only apply, that basically separate between rental properties and owner-occupied properties are violations of the Equal Protection Clause. And I just would like your legal, opinion as to how we come away from that in passing a statute like this.
Just to clarify our previous conversation, the California cases you mentioned never came out of my mouth.
I brought you cases.
Okay,
I did my own due diligence.
I don't believe them to be relevant in this jurisdiction. There is one case from the Syracuse, it's Topper v. Syracuse. I shared it with you earlier. It's a very similar in statute as it regulates parking and distinguishes between owner-occupied and non-owner-occupied parcels. The statute in the Syracuse case was deemed to be invalid. However, the last sentence of the holding states quite clearly, even though such a distinction may be constitutionally valid, it is invalid under the uniformity requirements of the general city law and the City of Syracuse Charter. So again, as I stated earlier, sometimes when you do this type of legislation, you need to be in the gray. Clearly, the intent of this court and this decision and this holding was not to say you can't. In fact, it clearly says you may. It may be constitutional, and that's enough for me to bring it to this board, and maybe it will survive scrutiny.
Okay, and maybe. Okay, and I understand that, because none of us are judges here. We're not sitting here. We don't have the highest court ruling on this issue yet, and I understand that. But up until this point, I've been working with the Stony Brook concerned homeowners, other members of the community, trying our best, and the supervisor, actually, to try our best to strike the perfect balance, to make sure that we deal with what I consider and what the courts have considered to be a legitimate purpose of trying to avoid overcrowding of homes, to make sure that, people's quality of life is upheld as it relates to, illegal housing. And I've put forward a number of code amendments that I think supported that. And I've worked with Stony Brook University as well as community groups to consistently address this issue. And there were a number of proposals that came forward throughout my term that we said, this is clearly, it appears to be unconstitutional. And I think my concern is more so, and I'm appealing to my colleagues, because I understand everyone here, wants to try to address the illegal housing issue. And many of the community here that's clapping wants to address this issue as well. But I think it's important that we're careful as to the statutes that we pass when we know that even though there may not be binding authority, that there's persuasive authority not only in the state of New York, but in a number of other states that indicate a statute such as this that's not applied evenly to all households, meaning the owners of homes as well as the owners of homes that rent, is a violation of the Equal Protection Clause. Now, the actual case that you mentioned to me and just spoke of, I know that they spoke specifically about the state law and that municipal law, and they dealt with that in particular. They didn't deal, from what I've read, with the equal protection law. And when we're dealing with the equal protection laws, I think it's important that we look at what other municipalities have done and whether those have been challenged. And they clearly have been challenged across the state for codes that are almost identical to the one that we're putting forward.
Across the state or the country?
I'm sorry?
Across the state. I don't mean to interrupt.
I'm sorry, across the country. So there were different states. Thank you for correcting me.
Thank you, Councilman.
So what happens is, I think that us looking to other towns, the eastern towns that you mentioned, and saying, well, they haven't been challenged yet, so we should put forward a code. And
Councilman, I have to stop you there because that's an unfair characterization of my presentation. I merely mentioned that other East End towns are doing this, and we're falling in line to what they're doing to combat similar and like problems. I certainly didn't propose this legislation tonight to say they're doing it, so we should.
No. Okay. And I apologize if it came off that way. I highly respect the law department. I 99.9% of the time defer to the law department, but this code that we are proposing is clear to me that it smells of unconstitutionality. It does. And yes, no one may challenge us. But the question that I have is, I'm looking at the budget that the proposed budget that the supervisor just proposed. And we're adding additional investigators. We're adding additional attorneys, litigation attorneys. Clearly, there's a lot of work that's out there that the town has that we need more staff for. Why would we put ourselves in a situation where we're inviting a lawsuit so we can see if, in fact, we may survive scrutiny? The fact is, I have cases in front of me that specifically state, and I'm just going to read a few of the comments in the cases just so my colleagues understand where I'm coming from.
Could you also read the state they're from?
Oh, yes, absolutely.
Thank you.
And I've indicated that they're from different states. I have one from the Court of Appeals in California, which says let me go back. Equal protection does not demand that a statute apply equally to all persons. it does require that persons similarly situated with respect to the legitimate purpose of the law receive like treatment. We've agreed that the legitimate purpose is the overcrowding of homes, making...
Councilwoman, the words overcrowding of homes never came out of my mouth when I made my presentation. I spoke of public safety,
Okay.
the cars on the streets, safe passage, narrow roadways.
Okay.
That's what I spoke of.
I'll adopt that. I'll adopt that. So let's assume that we agree that that's the legitimate purpose that we're creating this statute for. Then it says owners and tenants are similarly situated with respect to the legitimate purpose where both groups can contribute to that purpose. So in a situation like this, owners of homes and renters can both contribute to what we're trying to achieve. It says here that if occupancy restrictions designed to mitigate neighborhood overcrowding problems are reasonably applied to tenants, they should just as reasonably be applied to homeowners. And we can perceive of no justification for making a distinction between the two types of detached dwelling residents.
However, the California case aside, the seminal case in reference to that very point comes from the town of Brookhaven that says you can treat these people differently in furtherance of the legitimate, rational governmental purpose.
Owner occupied with accessory uses. And it was very clear, that case was very clear that it was because it was owner occupied with an accessory use. It wasn't dealing with the owner's use to be able to rent their property. It's two different things. So I understand it, and we can go back and forth as though we were before a judge. What I'm trying to do is appeal to my colleagues to, if this gets litigated, we're using taxpayer dollars. Okay, we're using taxpayer dollars to defend it. Do we want to be, and you ask yourselves that, do we want to be that town that wants to test the waters in New York to see if, in fact, this violates the Equal Protection Clause, particularly since we have cases in other states that indicate that statutes such as this, almost identical to this, are violations of the Equal Protection Clause. So, and one last point that I want to make is, we live in a town, the second largest town in the state of New York, largest town in Suffolk County. We don't only have owners of homes. We have a lot of renters. We have thousands of renters. And not many of those renters are not illegal renters. We do have our fair share, and clearly that's our problem. This is why we're all here today, trying to fix this problem. But should the legal renters be impacted when they've been living there for years, contributing to the community, and by chance have their grandparents live with them? They have 2 kids or 3 kids and only have a 3-bedroom. And now the husband can't have a car, and the wife, the 2 grandparents, and their 2 children, because it would be in violation. Those are things that we need to consider. Those are the practical things I think we should be taking into consideration.
Valerie, if I may, I think we would be, in that, a lot of the situations you've brought up, they'd be in violation, wouldn't be eligible for a rental permit. Nevertheless, if you had all of these kids, 2 parents, grandparents, in a 3-bedroom house, you wouldn't get a rental permit to begin with. But let me tell you, if you take your argument, and I believe in what our deputy town attorney had to say, if we took your argument in that we never had binding authority somewhere or some case law to actually do something, I'd tell you I don't think we'd get anything done here if we always had to look for a guiding authority. Here in Syracuse, was it Syracuse?
Yes, sir.
Syracuse, you have a case whereby it says we didn't get to the merits. Procedurally, because of the charter of the city of Syracuse, they never got to the merits of the case, but they acknowledge it may be constitutional and legal to have this law on the books. Up in your district also, a case I'm pretty sure you're very well aware of in the village of Belterre, with Stony Brook students, went all the way up to the United States Supreme Court. Somebody back then, I'm sure, sitting on this town board, probably in the 70s, 80s, whoever was on the board, I bet you somebody made the same argument. Even some of those former board members, I think, owned rental homes, going back into the annals of history. And you know what? The town board then, as I believe it will now, took up a law to try to protect the community, the health, safety, and welfare of that community. And If we live in fear of litigation, obviously no one here wants to discriminate against anyone. But if we live in fear of litigation, in that our law will not be upheld, a law I believe we all may pass, or maybe not all of us, righteously, then you know what? I'm not sure that this town board will effectively be able to protect the health, safety, and welfare of the residents that we represent.
Well,
Councilwoman, also
if I can respond to that,
Can I get in here just 1 second?
We're going to let every member of the board speak.
Great.
Valerie's had a long time. I think we have other board members that want to comment.
Yes.
on it.
I understand, but we're here.
I
We're
would
not
like
going
to
anywhere.
make a brief comment as a former social studies teacher who taught the Constitution. And I do want to underscore that we are talking about the Constitution of the United States. And it is the Constitution of the United States that protects all of us, protects all of our rights. And what we're talking about here in the 14th Amendment is the Equal Protection Clause. That means that our laws have to deal with people equally. We can't enforce a law on one group of people and not another. And that's what we're trying to do here. We are saying that renters have to abide by a different type of set of rules than those who own. So, I have an issue with this. I have an issue with this is because it is not abiding by the Constitution, and I think that every member here, whether you are a conservative, a Republican, or a Democrat, is here, and we have to protect that Constitution, and particularly the rights in that Constitution. And that is enormously important. We are on a slippery slope here.
Okay. Kevin, did you want to comment?
Yeah, I'll comment. We've made a lot of comments about students. This isn't just about students that live in Stony Brook.
I agree.
This is about the whole town.
That's right.
This is about my district, all districts. We're talking a lot about students. I know we have a lot of the Stony Brook residents that are here. This is a widespread problem. I go around and I talk to a lot of households, and I talk to a lot of people, and they say, hey, that house right across the street, it's a 3-bedroom house, and they have 7 cars parked in front of it. There's something going on there. And also with this issue, we're talking about town law. What about the safety issue? What about our fire departments? We're talking about South Country Ambulance. What about our fire departments? That in a 3-bedroom house, there's 7 cars in front. How many people are living in that house? How many are in the basement? If there's a fire there, how many people are in danger of losing their lives because we have an overcrowded house? As we move along with this, it's just another tool for our inspectors to be able to go out
That
and
violates
go
the
after,
Constitution.
Well, you could violate the Constitution, but we're here to challenge, to make sure we solve problems, Councilwoman. No offense. We're here to solve problems. And if this is something that is a tool that allows us to protect our citizens and to uphold, the sanctity of our neighborhoods by getting cars off the street, then that's something that we should go to court and challenge, and we should set the precedent.
Councilman LaBelle.
That's where we should be, and we should be going at the end of the day. I'm tired of our laws. We have to start going after a lot of the slumlords that are around, that are sitting here renting these houses to far too many people. And exactly, and I'm hearing from neighbors all over the place, from Selden, Center East, Farmingville, all around when I go door to door, that these people are making money off people, and they don't care about their homes. They're running down the houses. We need to attack them aggressively, and this is the first part of doing it.
Councilman LaValle, I must say, and I have Dave Moran here who deals with these cases on a regular basis, we have been going after them aggressively. We have court matters, we're arguing things on appeal. Supervisor Romaine is going to the courthouse, making sure that, we can have additional days. I mean, we're attacking this from every aspect, but people do have rights. And there are mechanisms that are in place that if someone sees 7 cars in front of a home, it's one of the things that make the investigators say, wait a minute, is this an illegal use? And that's something that so we have mechanisms for that. But if we want to address this, what we call a legitimate interest of public safety, then the proper way, which I don't agree with, let me just be clear, because I don't agree with that one either. I think it affects everyone and doesn't achieve the goal. But the proper way would be to apply it to everyone. And that's the way you avoid the constitutional issue. I'm sure that many people in this crowd who own their home don't want to have that imposed upon them. I wouldn't want to have it imposed upon me as a renter or an owner. So if we want to deal with the public safety issue, if that is the true reason we're putting this statute forward, then we're supposed to be trying to apply this to everyone.
Let me be honest, Councilwoman. There is not a homeowner in this room today that would have 37 people living in their house. The only way that this is going to be affected is about renters and people renting houses illegally. There's nobody in this room that's going to sit here and have, how many people of their family. I had a big family. I had 4 brothers and sisters. And your family was bigger too. But we respected our neighborhood, and neighbors aren't calling about that. They're calling about having 7 cars, 1 on the grass, 3 in front of the house, people all around not getting taken care of. This is another tool for us to attack those homes.
We have things in place. We have things in place with respect to grass.
We have the public to speak.
Okay.
Councilwoman Cartwright, you've had more than enough time. I want to see if any of your other colleagues have any.
Now, Supervisor Romaine, I'd like to just, I agree with Councilman Lavelle. Obviously, this is a quality of life issue that obviously we're not doing a good job about. These folks are breaking the law, and that's the bottom line. And then you throw in the safety issue, and I could tell you in my council district, I get 3 or 4 calls a week on this matter. And honestly, my hands are tied sometimes. So I think this is the right way to go, and I agree with my colleagues, Councilman Lavelle.
Well, I'll end the debate amongst the board members and turn it over to the public, but I'll end with this. Many weekends, I get emails. I get emails that there's parties. I get informed by my investigators that there are landlords building 11-bedroom homes without COs who are in violation of our law. I get all types of correspondence about activities that really impact the quality of life. And I think of those people. This is not a law to hurt renters. This is a law to control parking so that we don't have 10 or 11 cars in front of a house, unless there's a legitimate reason, because a law provides an appeals process. This is a situation that developed not only in certain areas, developed out east. Both the towns of Southampton and East Hampton have passed similar legislation, and they've been on the books for a long time. This is an attempt for us to send a very clear message. Respect your neighborhoods. This gives us a tool to say to people, respect your neighbors. Don't go in there and hurt neighborhoods. And some landlords, some, are not responsible. They don't get rental permits. They don't have COs. They flout the law of this town. And as long as I stay as supervisor, those who flout this law, not only this, but all the other laws that we passed to protect neighborhoods, we will continue. We are not going to get instantaneous results. You know why? Because we're government. And guess what we have to do that they don't? We have to follow the law. And it goes through the courts. And it takes time. But that has not weakened my resolve, because I want people to obey. We require COs, certificates of occupancy, for health and safety reasons. We require rental permits for the exact same reasons. We limit the amount that you can rent to people not living as a family to no more than 4 people for a reason in a single-family home. And see, well, you can't do this. It's not constitutional. We have had on the books an accessory apartment where if you want to put an extra apartment in your house, you have to apply for a permit. And one of those things, regardless of how much parking is available on the street, is that you must provide off-street parking. I don't think that's unconstitutional.
It's not.
And this is in that vein where you limit. You can have a car for every bedroom in the house plus 1. So if you have a 4-bedroom house, you can have 5 cars. Now, if you want more than 5 cars and you have a need, you can go to the appeals process, appeal in front of the ZBA, and state your need and rely on them to address that. So I think the law has some meaning. I hope it will be effective. We may decide after we pass it and it's been enforced that it isn't working. We may do that. But you know what? I'm one of those guys that believe in trying. And if this doesn't work, maybe this will work, and maybe this will work, and maybe this will work. But the message is respect our neighbors, respect our neighborhoods. Thank you.
Are we ready to hear speakers?
Absolutely. And hopefully we have some people that are landlords, because I'm going to ask them about their rental permits and their COs if they come up and speak.
I'm sorry, Madam Clerk, did we have people that wrote in letters with respect to this hearing?
Just from you.
I said that in my opening remarks, we had one letter of opposition.
It was 2 letters. I just wanted to make sure that one was from the Civic, and it was signed off with the Civic header, and the other one was from, I believe, the landlords and tenants. I just want to make sure.
The Civic Association took a vote on this?
I don't know what they did. There's been some concern about that, but 2 letters came in to the town board supervisor, and procedure is we indicate what the letters are for the record. That's all I'm asking to do.
I mentioned the one letter because that is all that I have in my folder.
Okay.
That letter, the second letter you're talking about, should have been delivered to the clerk's office for me to distribute to the town council. If it went directly to the council, then I do not have it in my file.
Which one do you have?
I have a letter dated September 10th from the Coalition of Landlords and Tenants of Stony Brook.
Okay, thank you.
That is the only letter I have in my file.
Thank you.
Our first 4 speakers, Sean Nuzzo, Bruce Sander, Neil Host, and Salvatore Pitti, in that order. You are each going to have 5 minutes to speak, and the clock is in front of you, so watch it, because I'll stop you when it's up. And if you will all please just raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. Mr. Nuzzo, you can take the mic. You're up first.
Sean Nuzzo, I'm the president of the Civic Association of the Setaucus and Stony Brook. This is a tough decision, no doubt about it. It raises the question of whether or not we can be fundamentally supportive of a law that's good, but at the same time morally oppose it for its execution. So let me try to explain. So I grew up in Selden, and as a kid, you'd play in the street. You'd play street hockey, you'd play football, tackle on the sidelines, two-hand touch in the street. You'd ride your bikes. And on streets where there were no cars, it was better, it was safer, it was nicer. Over time, that's changed, unfortunately. It's not safe. And a lot of it now, as an adult and as a first responder, I see that it's difficult with a lot of cars on the street. It makes the streetscapes crummy. It's one of these things where it would be, in a perfect, ideal world, we wouldn't have on-street parking. People in residential neighborhoods would be able to park on the street, on their own property. But when we take a closer look at this clearly isn't about street parking at all, is it? This is about targeting a minority community in Brookhaven, minority residents, who the town attorney called these people. I don't know what that means. But the town, it's interesting to note.
Are you saying minority? Are you saying that
this
law
targets?
Why don't we let the speaker
he can have his time, and
Mr. Panico.
we can always ask questions. Are you saying minority in that this law aims to, in some way, disparage minority as in race? Or are you
no.
Renters a minority?
Renters as a minority.
Okay.
So renters
may not have been clear. It wasn't clear to me.
And renters in the town of Brookhaven as a minority community versus homeowners.
So I just wanted to establish your point.
Okay. The town offered no empirical data about the need for this. So we heard a lot about public safety, and we heard a lot about streetscapes, and it all makes sense. But we didn't hear any kind of legal data like, we've done an estimate, and 75% of the cars parked on the street are from rental properties. That's why we should be targeting renters. And so that wasn't implied in the testimony. And if the town did that kind of survey, they withheld it, from its proceedings. What the town is presenting are 2 separate and unequal laws. If it's a good law, let it be implemented townwide. And maybe that's the mark of a good law, is whether or not we ourselves are willing to be subjected to it. Because if you're advocating for a law, but you yourself want to be exempt from it, what do we have there? So the position of the Civic is that our laws should apply equally to all.
Are you done, sir?
Yes.
So let me just ask again, I'll ask the question I asked Mr. Moran. In the same vein of thought, would you say then those who occupy an entire home as renters, renting a whole entire home in any community, should also be allowed to apply for an accessory apartment permit? Because right now, the town does not allow that. We treat owner-occupied and renters differently.
This proceeding is about public roadways, and so, if you have a question about public roadways.
You said that we should not treat people, and I'm trying to make it clear, because what the town attorney, the deputy town attorney, said was that we are controlling the use, not the user. And I brought up to our deputy town attorney, Dave Moran, is it in the same vein of thought, being the law, that we allow owner-occupied residents of a home to apply for an accessory apartment permit, but we do not allow those that occupy an entire home to apply for the same permit? So I ask you, sir, do you believe if we are to equally apply the law in that situation, which also would be potentially an equal protection argument, that we should allow those that occupy an entire home, not owned but rented, to apply for an accessory apartment permit?
We didn't discuss that as a civic board. What we discussed was the use of our public roadways.
Only owners. I mean, obviously, you can't apply for an accessory apartment permit if you don't
Obviously,
own
you say
the
obviously,
home.
why not?
Because it would be like somebody applying for something for my house. They do not own my house. I own my house. That's just a pure...
Oh, no, but the argument is disparate treatment
That's a straw
for
man
renters.
that you're setting up. It is ridiculous.
Well, Connie, suppose the owner applied for a rental permit and an accessory apartment. Is that, we can't do that under the law. Does that mean we treat that owner, because he has a rental permit, differently than we treat property owners?
We
and
do.
The point is, that is not the case. I think that's the point Deputy Supervisor is trying to make.
And I ask you because I want to flush out the whole discussion here, because the town does already treat the two entities, owned and rented, differently under the code, and no one has ever brought that up, because I brought that up to our town attorney, and I've had discussions with Councilwoman Cartwright. I understand what you're saying, I understand what the councilwoman is saying, and I understand what our deputy town attorney is saying. So it wasn't, you were the first person to speak, so I asked you that question, but I think it's a very valid distinction that the town code already makes.
Oh, I'm not a lawyer. I don't, I wouldn't be able to comment on the legality of your town codes. But, we're just, it sounds like you have two separate and unequal laws concerning public space. That's something that the Civic is morally opposed to, because we think that it should be one law equal to all.
Mr. Nuzzo, I did have your letter. It just was not in this.
It was a letter of modification more than opposition, I
It was
guess.
a letter that dated September 8th. I do
Right.
have it. In my email, it was
Thank
sent to
you.
me. Just isn't in the folder tonight. I apologize. Our next speaker is Mr. Sander.
Good evening. I'm Bruce Sander. I'm president of the Stony Brook Concern Homeowners. Established about 2.5 years ago. We now are numbering in 1,450 homeowners in our group at this point. Quite a large organization concerned about the illegal housing. I would like to rise in support of this introductory law, number 23, amending Chapter 82, the Code of Brookhaven. I did not send a letter to the board because I believe face-to-face means much more than a piece of paper, and I believe in trust. I am sure the board is more than aware of the number of rental homes in the Three Village area and around the town of Brookhaven. In Three Village, we are primarily dealing with college boarding houses that are numerous students from Stony Brook University. Many of them are illegal. Just yesterday, I reported a rental property on Stony Brook Road. Had 9 cars out in front, some on the lawn. Over the weekend, I reported another house, also on Stony Brook, with 10 cars parked. Please understand, when I report a house or something like this, I have personally witnessed it over a period of at least a week to verify that these cars are not just visitors, but appear to be tenants. Can you imagine if each one of these college students had friends over? Now the 10 cars become 20. What a mess. Now the landlords are telling their students to park around the corner and walk to their properties so that they're not noticed in these houses, except we, the legitimate homeowners, notice them. We know who they are. We live in a single-family neighborhood whose streets and driveways are not designed for this type of congestion. The problem magnifies itself during the winter when the snow removal vehicles cannot plow the streets properly because they are jam-packed with student cars. What we wind up sometimes is a very narrow plowed path, which is extremely dangerous to all, along with the fact that many of these landlords charge the students additional rent to park in the driveway, which causes even more havoc in the streets. What about the legitimate homeowners, the people that live there, that shovel their driveways and have to go around these cars, these student cars parked in the street? This amendment to the code would be a non-issue for landlords if they truly had only 4 students and obeyed the law. This is an issue for them because they knowingly rent to many, many more than the code allows. I believe that this addition to the town code will give us just another tool to help combat the illegal housing issue destroying our single-family neighborhoods. It is my understanding that the current Three Village Civic Association letter, whether the Civic Board agreed to the letter or not, the President apparently sent a note to the Board to make a stand against this proposition. However, let's take this letter and really identify its source. You will clearly see that it does not represent the community which it serves, but rather a select few of the Executive Board. One member, I believe, is a renter himself. The other, vice president of the board, owns 4 college boarding houses, 2 located on Stony Brook Road. If this is not self-serving, then I do not know what is. So please take these facts into account when giving this letter any merit at all. I ask for all of your support for this challenge tonight, and I thank you, each of you, for what you do to the communities that you serve every day on this board. Thank you.
Neil Host, please take the mic.
Good evening. Thank you for allowing me to speak at this meeting. My question about the public law. I have a house on my block that is owned by somebody who lives in the neighborhood. It's been vacant for the last 4 years that I've lived on this block. And they have 4 vehicles, 3 with plates that were put on 3 years ago, and I'll guarantee you have never been re-registered, and a new RV that got put in the driveway last week. How does this public law affect that house? 2, how does that affect the value of my house? I don't know about you, but I'm a working class person. My biggest investment is my house. And we're allowing these people to come in and degrade our neighborhoods and devaluate my value. When I retire here in a few years, I hope that I can even get my money back from the house that I bought. Now, maybe you have second jobs or higher other interests, but I don't know about you, especially you, Councilman. But I would appreciate if you apply the vehicle law to everybody. You want to argue the point that it's unfair just to the renters, then apply it to me. I am willing to accept that law and abide by that law. I am not putting 14 cars in front of my house. I'm not having them in front of my house. And you talk about spending town money fighting this lawsuit? Well, I heard before, gentlemen over here complaining about the amount of time you've wasted talking about hedges in a park. I'm sorry, that might only be 2 people it's affecting. We're affecting 1,400 people here. I think, yes, it's worth the money to fight for this law. Thank you very much.
One second, please. Mr. Petey, thank you.
Good evening. My name's Salvatore Pitti from Port Jefferson Station. I'm also a retired NYPD officer. I've dealt with lots of landlord-tenant nonsense in my career, so I've seen pretty much most of it. Whether this law is passed or not, evenly or unequally, whatever the case may be, my personal opinion is I think it's just a Band-Aid, okay? The problems we have out there, the attorney said it before when Councilwoman Cartwright said it. Are there going to be unscrupulous people that try to circumvent the law? Yes. Why? They're the ones we're trying to get rid of. We don't have to worry about the League of Renters. We don't have to worry about the homeowners. We're all doing the right thing. We're the ones who want them out of our communities. Okay, so just passing this law, will it work for a few months? I believe it will. And then eventually they're going to find a way to circumvent it. Cars are going to be found on the street, becoming a safety issue, which the attorney's trying to prevent. Okay, it's going to be a problem for our firemen, our emergency vehicles. It's going to be a problem for our snow vehicles. It's just a Band-Aid that's not working. Okay, on top of that, I've dealt with your law department in the past because I also run the Crime Awareness Committee in Port Jefferson Station. All right, most of their issues is they're never able to find or catch these people in the act. Why? They work Monday through Friday, 9 to 5. Okay? These people are not home Monday through Friday, 9 to 5. They're out working. Okay? There's a house right up the block from me. One of the main reasons I got involved in the committee. All right? There's 7 cars in that driveway constantly. Will this law work? Yeah, it'll bother them for about a month. And then their cars are going to be in front of my house or somewhere else bothering somebody else. And if you start looking at registrations, I guarantee you none of the registrations will come back to that house. So there's no way a police officer who's already taxed, as Councilman Laval said, are going to be able to do anything about it. And your law enforcement ain't going to be able to do anything about it because there's no way to prove that the car belongs to that house. I mean, will the law work? Yes. And I applaud the fact that you're looking to methods to fix these problems. But the fact is that unless the enforcement increases and you find a way to do night hours or different hours and actually follow through on these people, there is no way you're going to be able to do anything with any of these new laws. They know it. They know how to skirt it. They find ways around it. That is what they do. That is why we have a problem. So unless you can enforce it at different times and different hours, it's a problem that will never be fixed, unfortunately, and it'll just keep getting worse. Thank you.
Thank you very much. You're right.
No more speakers, sir.
No more speakers? Okay. Is there a motion to close this public hearing?
So moved.
All those in favor to close?
Aye. Okay, now that this public hearing has been closed, is there a motion forthcoming? Motion of approval. I will make that motion. Okay.
Do I have a second?
Second.
All those in favor?
Aye.
Opposed?
Proposal.
Motion carries.
Okay.